Attorney Laura Anthony, founding partner of Legal and Compliance, a full-service corporate securities and business transactions law firm. Today is the continuation in a LawCast series talking about U.S. investments in foreign businesses and foreign companies trading in the U.S. public markets. In the last few LawCasts in this series, I described the registration rules for foreign private issuers and the differences in the general disclosure and reporting rules from domestic companies. The deregistration rules for a foreign private issuer are also different from those for domestic companies. A foreign private issuer may deregister if the average daily volume of trading of its securities in the U.S. for a recent 12-month period is less than 5% of the worldwide average daily trading volume, or the company has fewer than 300 shareholders worldwide. In addition, the company must have been a reporting company in the U.S. for at least 1 year and have filed at least one annual report and be current in all reports. It must not have registered securities for sale in the U.S. in the last 12 months and must have maintained a listing of its securities in its primary trading market for at least 12 months prior to deregistration. In this LawCast series, I have also mentioned American Depository Receipts, or ADRs. An ADR is a certificate that evidences ownership of American Depository Shares, or ADS, which, in turn, reflect a specified interest in a foreign company's shares. Technically, the ADR is a certificate reflecting ownership of an ADS, but in practice, market participants just use the term ADR to reflect both. An ADR trades in U.S. dollars and clears through the U.S. DTC system, thus avoiding foreign currency issues. ADRs are issued by a U.S. bank, which in turn, either directly or indirectly, through a relationship with a foreign custodian bank, holds a deposit of the underlying foreign company's shares. ADR securities must either be subject to the Exchange Act reporting requirements or be exempt under Rule 12G3-2B. ADRs are always registered on Form F6. In this LawCast series, I have also detailed the definition of a foreign private issuer for determining the availability of the F series of forms and scaled back disclosure and reporting requirements available to these foreign issuers. OTC Markets allows for a listing and trading of foreign entities on the OTCQX and OTCQB that do not meet the technical definition of a foreign private issuer as long as such company has its securities listed on a qualifying foreign stock exchange for a minimum of the preceding 40 calendar days. If the company does not meet the definition of foreign private issuer, it still must fully comply with Exchange Act Rule 12G3-2B and comply with the OTC Markets Alternative Reporting Standards. Accordingly, many foreign listed companies opt to trade on the OTC markets without registering with or becoming subject to SEC reporting requirements. I'm securities attorney Laura Anthony, founding partner of Legal and Compliance and producer of LawCast. Should you have any questions about today's topic, please visit securitieslawblog.com and lawcast.com or contact me directly. Inquiries of a technical nature are always encouraged.